We have two more cases on the docket for today, and the first one is CRUZ versus Rodriguez in COUGHLIN.
Yes, sir.
Are you ready to proceed, counsel?
Yes, Judge.
You wish to reserve any time?
I'd like to reserve 5 minutes, Judge.
You may begin.
May it please the Court. My name is Sylvia Gruner, and along with Amy Romaine, we represent YESENIA and CRUZ. This is a dog bite case out of Orange County. My client, CRUZ, is a young lady who was visiting at a neighbor's home and was bitten in the face by a pit bull. This is a neighbor that she had visited in the past, and the pit bull was one that she was somewhat familiar with. There were 2 pit bulls actually at the home. The pit bull that bit her, its name was Macho. The other pit bull's name is Daisha.
Counsel?
Yes, sir.
Much has been made about the propensities of a pit bull to attack people. If this were a Cocker Spaniel, would you be here?
You know, Judge, I sincerely doubt that I would be here if this was a Cocker Spaniel, since in this case, John COUGHLIN, the landlord in this case, did not, in his testimony, admit to any problem, prior knowledge, prior indication that there would be a problem with a dog such as a Cocker Spaniel. But he did specifically, in his own testimony, exclude or purportedly exclude from tenancy those types of dogs that gave problems in the past.
It just seems to me, in reading the briefs and the record and all, that what you're really asking us to do is to adopt a rule which says that where pit bulls are concerned, there's a presumption that they're going to be vicious and hurt somebody.
Yes, sir, and that is a pronouncement that's actually been made by sister courts to this court, that pit bulls and other animals that have a lineage, like Rottweilers and things of that nature, have a lineage that would predispose those animals to dangerous propensities. Now, a pit bull has a little bit worse rap, because the pit bull, once it starts an attack, it does not want to let go. They almost have to be beaten off of the person. So I am asking this court actually to follow its sister court. I think it's the 2nd DCA that finds...
What's the case site for that?
It is, I believe, Judge, it is Ward versus Young, 504 Southern 2nd 528. It's the 2nd DCA opinion out of 1987.
That case doesn't hold that there's a presumption that where it's a pit bull, it's got a dangerous propensity, or that, you know, the owner or the landlord or anybody else is put on notice that it's going to hurt somebody, does it?
No, sir, I don't believe that case has that. I believe that case stands more for the proposition that the knowledge of the person that's collecting the rent can be imputed to, in that case, a landlord, and in this case we're using that certainly by analogy for that proposition.
I read the cited cases. I recall a first DCA case where they found that the summary judgment was appropriate because there was no indication that the landlord knew or should have known the vicious propensities of the pit bull, which would indicate a different rule. In other words, that you have to know, or that the dog itself, not a particular breed, but the dog itself has to have a propensity toward that kind of...
You're absolutely correct, Judge.
So, but I don't recall reading any case or seeing any treatise anywhere inside or outside of Florida that said that it's enough if the landlord knows or should have known that the tenant had a pit bull or other breed of dog that might be prone to viciousness.
Actually, Your Honor, I believe that the case Descent, which is a first DCA opinion 1989, 543-438, is the site. In that case, there was an issue on the lineage of the dog as well. And in the case law involved in the research for this particular brief, the lineage has certainly played a part, since pit bull is a breed that's recognized as being...
I'm guessing a little confused. Are you saying that there's another Florida DCA that's adopted a rule that lineage is enough standing alone?
I believe that there is, Your Honor. I can, on the return, on my rebuttal, I will locate that case and give you the site for it. But there is...
But you agree that if that's not the case, that there's been certainly no showing that anybody knew that this dog was vicious, or that this dog had had attacked anybody or done anything vicious toward any person before.
For this particular dog, I believe that there is record evidence in the affidavit of YESENIA CRUZ, the mother of the young girl who was bitten, that this dog had actually bitten 2 people prior to this occasion when it bit her daughter. In addition to that, I believe that there's record that Jack COUGHLIN, who is the landlord in this case, he testified during his deposition testimony that is one of the reasons that he tries to or does prohibit these animals from tenants in his rental homes, because he has read a lot of things about the vicious nature of these dogs. And he has a laundry list of Dobermans, Rottweilers, Pit Bulls, and I think in one of the witnesses misspoke and instead of Doberman said Dachshund.
But there was no record evidence that the landlord knew that these dogs were at the residence.
No, ma'am. There is no direct record evidence that Mr. COUGHLIN knew that these animals were at this residence. That knowledge would have to be imputed to him through his agent that went to this home prior to the incident involved and were at the home for 8 hours conducting repairs.
That was a plumber, correct?
Yes, sir.
All right, go ahead.
And that agent wasn't his direct agent, it was somebody who was doing repairs, a secondary.
It's a secondary agent, someone who was doing repairs. During the deposition of Mr. COUGHLIN, he testified that he had dedicated people for dedicated repairs in all of his rental homes. Unfortunately, in discovering the identity of those repair people, Mr. COUGHLIN, in his answers to discovery, indicated that despite a diligent search, he was unable to provide us with the names and addresses of those people, or even when they performed those repairs to this rental home. So we were precluded in that discovery based on his own limitations.
Counselor, as I understand it, there was a no-dog policy that the landlord had in place.
He had a no-dog policy that
if I may, let me just, let's assume there's a no-dog policy. And the rule of law is that the landlord can still be liable if he knew that the dog was vicious and had some method of controlling its presence. What evidence is there in the record that he had any control over the presence of that dog when he had imposed a no-dog rule?
In this case, Judge, the record evidence is that Mr. COUGHLIN went by all of his rental homes on a very frequent basis, and in this one he actually testified at least 2 or 3 times a week that he drove by. And if you look at the later record evidence after this dog bite occurred, he enforced that by having given them, I think, 24 hours to remove the dog Baisha from the rental property. So he does have a method of enforcement, and he also had a method of discovery.
But he didn't know about Baisha until like 6 months after the first dog bite, right?
That's correct, Judge. He did not know about Baisha. There was an indication in the record that they had hidden not only the presence of one dog, but also the presence of 2.
So if they were hiding it from him, how can he be imputed to know this? If he goes by the apartment and they don't let him see the dogs, how is he imputed to know this? If the dogs were only kept inside, I would agree with this court that he would have a very limited opportunity to discover these animals. However, these dogs were not only kept inside. There's record evidence that they were kept in the fenced enclosure in the backyard. And as he indicated in his deposition testimony, he drove by these rental homes several times a week. He certainly had an opportunity to see the dogs in their enclosures in the backyard or running around in the backyard.
Where is, because I don't see that cite to the record in your brief, where does it say in the brief that driving by it from the front yard you can see the shed that was described as to where the dog was kept in the backyard when it was kept there?
There is not that record.
How are we supposed to infer that simply because he drove through the front yard and there was a fenced yard that he can see or should have seen dogs that may or may not have been there in the backyard, because the testimony was that they weren't kept there all the time?
I took it on an assumption, Your Honor, that the way he described it, that this house was on a path in his direction to go to the courthouse as he went for foreclosure sales or whatever. And I took it that this house was either at or near a corner so that it was visible. He did.
You're asking us to base this on sheer speculation, is that?
No, sir. I am not asking the court to base it on sheer speculation. I'm asking the court to base it on not only the fact that he regularly went by the home, there's also disputed record evidence that he was at the home on several occasions to pick up the rent checks, and there is at least direct statements from the CARMENRODRIGUEZ, the wife of one of the tenants, that she handed him a rent check at the home. So
there was also, in their record, wasn't there also evidence that they deliberately kept the dogs hidden when they knew he was coming to pick up the rent?
Well, Judge, there's record statements by Mr. Santiago and Ms. Rodriguez that they affirmatively tried to keep the dog hidden, but in the deposition of Mr. Santiago, he makes a statement that he lied to Jack Coughlin. He lied to him about the dog. And then he goes on in his deposition, and it's on page 57 of his deposition, that to say, I lied to him about the dog. I told him the dog wasn't ours. I told him the dog was a friend. That presupposes that Mr. Coughlin...
When I read that in the deposition, I thought, and maybe I'm taking it out of context, but I thought in context he was talking about after they initially when they disclosed it, when he was served with the lawsuit and discovered that they had had a dog, the initial response was, well, it wasn't our dog, and then eventually they admitted that it was, and then the landlord made him get rid of the second dog. So I did not read that as a statement that any time prior to the time that Mr. Coughlin found out about the dog because he was served with a lawsuit, that they had any conversation in which a dog was mentioned.
Well, Judge, I think that in that deposition is quite hard to read since Mr. Santiago has a tremendous language barrier. I believe that statement is capable of being read two ways, and certainly since there is record disputed evidence as to Mr. Coughlin either going to the home to pick up rent checks or running all over Orlando to pick up rent checks, I think that that's capable of being read two ways, and I think that the trial judge in this case had the opportunity to read that two ways. It certainly is disputed evidence, though, that would preclude summary judgment. And in this case, the appellants rely on Petrushka. It is a pronouncement in 2005 by this court that the trial court below, in considering summary judgment, uses everything. They use the discovery, the pleadings, affidavits, and in this case, the affidavits themselves offered their own disputed record evidence. There was a statement in the record in this case that there was affidavits drafted, and it's unclear by whom they were drafted, but they were certainly presented by Mr. Coughlin to Mr. Santiago and Ms. Rodriguez. There is a dispute in the record. Mr. Santiago at one point says that Mr. Coughlin, he believed, read him his entire affidavit, since he can't read or write English, and yet in his deposition testimony, when I am reading to him the particular statement that he has now affirmatively signed for, he says, no, Mr. Coughlin did not read me those statements. So I believe in this case, the record evidence is certainly in dispute because of those affidavits. Both Mr. Santiago, who's a tenant, and Ms. Rodriguez, who's a tenant, both those individuals disavow certain statements in their affidavits. In fact, Ms. Rodriguez goes one step further. Even in her affidavit, she says that Jack Coughlin, her own personal knowledge, that Jack Coughlin did not know, nor could he have known, about the presence of this dog. Yet when she's asked that in her answers to interrogatories, she states he may have known. He may have known. He's come to the house on occasion. He certainly had repairmen there on occasion, and his repairmen had asked us to move the dog because they were concerned about the violent tendencies of that particular breed. So I believe that this record in this case is certainly susceptible of being read in offering different opinions. And I think that is the pronouncement basically that precluded summary judgment below. There are a number of irregularities in the affidavits in this case as well. The affidavit says they were procured. There's also the statement that money was lent during that time by Mr. Coughlin to Mr. Santiago, bringing into question the reason for the testimony, the reason...
Yes, you rely primarily in your argument that there's a disputed issue of fact on your client's affidavit.
Yes, sir, I do.
And your client's affidavit has a paragraph that says that Mr. Coughlin went by the house to get rent checks and went to make repairs according to Rodriguez.
Yes, sir, according to the children and Ms. Rodriguez.
Why is that sufficient under Rule 1.510 to create an issue of disputed fact? In other words, an affidavit has to be based on personal knowledge and has to be set forth evidence that would be admissible. And as I read that evidence, I see evidence that is not admissible for the truth of the matter asserted. In other words, I don't see how your client could stand up and testify as substantive evidence that, against Coughlin, she said that he did these things. Now, if she testified like she did in her, if Rodriguez testifies as she did in her affidavit that those things aren't true, she certainly could be impeached with that prior inconsistent statement. But I'm having a hard time with the concept that evidence that would only be admissible for the limited purpose of showing that someone's not telling the truth can be used to create a disputed issue of fact. Does that make sense?
Yes, sir, it does.
Okay. Can you address that?
There is a statement in this record, Judge, about what it is that YESENIA CRUZ was actually able to understand and what she put in her affidavit. And her yes, sir.
You have 5 minutes.
Thank you. And her statement is that Carmen Rodriguez and her children both made statements to her, and I believe that those statements, as admissions of party opponent, come under the exception to hearsay.
Certainly would be admissible against
Ms. Rodriguez.
But...
and I believe that they would also be admissible, Judge, for a limited, in fact, maybe not even a limited reason. They would also be They would also be admissible against Mr. Coughlin, since the record evidence in this case that Mr. Coughlin...
Under what hearsay exception would they be admissible against Mr. Coughlin?
Again, Judge, admission of
Ms. Rodriguez, out of course statements.
I think in this case, Judge, her statement is, not only is it bolstered, it is also countermanded by her statements in the statement given to Mr. Coughlin's insurance company, in her own affidavit that was procured by Mr. Coughlin. So I think that her statement does come in as substantive evidence. It's going to come in as an admission against her.
Right.
And since we're not going to have a separate courtroom for Mr. Coughlin, Mrs. Rodriguez, and Mr. Santiago, it's coming in to evidence.
If trial counsel is sharp, won't they make an objection and say this cannot be used as substantive evidence against my client, so I want a limiting instruction to the jury that says that this evidence is only to be considered with respect to Ms. Rodriguez?
I believe that limiting objection would be...
So if it's evidence that would not be substantive evidence admissible against Mr. Coughlin, then how does that create a disputed issue of fact with respect to his liability?
I believe that
if it's only impeachment evidence.
I believe that the disputed issue with regard to the imputed knowledge to Mr. Coughlin, we're getting back into the epistemology that's referenced in one of the cases about it's Sutherland, that you can't affirmatively swear that you don't have constructive knowledge of something else. Mr. Coughlin's own affidavit, it's self-serving. He says that he does not have knowledge, yet there are these other indications in the record that he at least had agents there at the property. These agents were there certainly with an opportunity to observe these animals. Whether or not they went back and told Mr. Coughlin about the animals on the property, presumably if they did...
I haven't heard an answer to the question of how evidence of an out-of-court statement by Rodriguez, which I'm not seeing a basis for it to come in as substantive evidence against COUGHLIN can be used to create a disputed issue of material fact to preclude summary judgment when you have all of these affidavits and all this other evidence which say pretty clearly that COUGHLIN had no knowledge whatsoever of this dog.
I believe that all of the, and Judge, to answer you with confining it specifically to Ms. Rodriguez's statement and Mr. Coughlin's liability vis-a-vis that statement, I don't believe that there is an exception under hearsay. But I believe all of the other record evidence that we have agents that were there on the property, we have disputed issues of where the checks were actually picked up, disputed issues of how many times Mr. Coughlin did or did not go to the home. I think that this is certainly an issue that the trier of fact in this case, a jury, would be allowed to ascertain. I believe that my time is up.
Good morning. May it please the Court, Grant Coughlin here for John Coughlin. I think, first of all, I'd like to point out the Court has correctly noticed the facts are not at issue. There is no notice, record notice, or evidence in the depositions or affidavits that Mr. Coughlin had notice of this dog. I think what we're here for today is a possible dispute of fact as whether there was constructive knowledge. There's no dispute that there is a common law cause of action for a dog bite against a non-owner of the dog in Florida. But there's a very important caveat to that rule, and I think the courts recognize that in the Sutherland and the Vasquez cases, where it said the two elements, could be 2.5 elements, the two elements would be prior knowledge of the dog on the premises, and the second important element would be knowledge of its dangerous propensities. I don't think we've gotten past the first element, and the second element you can't get to until you even have knowledge of that dog on the property. This court, the 5th DCA, held in the Bovis versus 7-Eleven case in 1987 that a tenant, not the landlord, had a continuing legal duty to inspect and maintain the safety of the property. For authority for this case, this court looked to the 5th DCA in California. And the case in that situation was Usello versus Laudenslayer, and in that situation, this court adopted the reasoning and said only actual, not constructive knowledge created a duty for a landlord to actively inspect the premises for a vicious dog. Very similar situation. The rule of law in California, ironically in the 5th DCA out there, was adopted in this 5th DCA here. So the rule in this district is there is no active duty for a landlord to proactively inspect his property. Can you say by driving by the property he should have seen the dog that was there on random occasions? And Ms. Rodriguez testified, and I think Mr. Santiago did as well, that they didn't even bring the dog to the property for full-time purposes until probably a couple of weeks before the dog bite. The dog bite, or arguably a scratch, happened May 29, 2004. Had they brought him to this property sometime in the beginning to end of May of 2004, if he arguably collected rent during the first month, which Ms. Rodriguez said he may have done, but Mr. Santiago says he never came to the property. If he had collected that first month's rent in March of 2004, because the lease began March 2004, he wouldn't have seen the dog anyways. And without this type of knowledge, actual knowledge, you don't get to the second element. You don't have a common law cause of action against the landlord. I think that's pretty clear in Florida. Arguably, the constructive knowledge can be asserted, but in this situation, the affidavits, the depositions, and everything that I sat through and I listened to and I paged through in the appellate record, everything that I've seen, I don't see a disputed fact in this case. If I may, I'd like to point the Court's attention to what it pointed out in the beginning of appellant's argument was Mr. Coughlin never allowed dogs on his property in the first place. And if you read in his deposition, which begins at record site page 302, the question was, when did you have a conversation with either Freddie Santiago or Carmen Rodriguez about keeping a dog on your property? His answer, immediately when Freddie called me and said, we're very interested in the property, I talked to him about how many people would be moving in, who would be moving in, how old they were, and then we went into pets. And he says, I said absolutely no pets. And he said after that, he goes, especially Dobermans, Rottweilers, German Shepherds, and Pit Bulls. And Freddie assured him, no, no, no. That's the record. Then the next question to him was, you have specific recollection as we sit here today of telling Carmen Rodriguez that? His answer, absolutely.
Let me ask you this legal question. Sort of theoretically, if there was evidence in a case that a landlord knew about a pit bull on the property, but there was no evidence that he knew that pit bull was in any way vicious. In other words, there are no bad dog signs or no call like one case that this dog's been lunging at children and growling at them and that kind of thing. So there's no evidence. Is there a case in Florida that says that that's enough, just knowledge of a particular breed of dog that might have a dangerous propensity?
If there is, I'm not aware of it, but as you probably know, there's not a lack of case law on this issue. You can go from the 1st through the 5th DCAs and research cited case law and cited case law, and they'll take you out to treatises. There's not one that I'm aware of. But assuming that fact in the record, I think if you then look at the case law that I think we have cited, Mr. Coughlin has cited, and I pretty much, when I drafted this response brief, I adopted Ms. Cruz's appellate brief and her initial brief in case law. I don't have a problem with it, because within the cases in her own brief, and as I elaborate in our brief, I count 1, 2 that actually affirm summary judgment. One was the Bessent case, another one was the Olav case, and I think if
was it Bessent a pit bull case?
I think you're right, it was, and I think the Olav court may have been a Rottweiler case. I'm sorry, was there a question?
And if I recall, wouldn't the Bessent case, the case in which I think it was the first DCA, said that even though this was a pit bull, basically there was no evidence that the landlord had knowledge of any dangerous propensity that the dog might have had.
Correct, You're right. And then in the Olav court, I think the court also held that the lack of knowledge precluded a common law action against the landlord. In that situation, the dog had escaped from the renter's backyard, and the plaintiff sued both the renter under the strict liability statute, which is what in our opinion should come into play here. Ms. Rodriguez is clearly the owner of this dog, and Mr. Santiago and Ms. Rodriguez had complete control over this dog. They admitted it in their affidavits, in their deposition. There's no question who owns this dog. But if you look further in what we're here for today is if you look further to the landlord for a financial liability for this dog, there is none, because they hid the dog. There's no question about that. Freddie, in his deposition, I call him Freddie, his name is Mr. Santiago. There's no question, if I can get back to my earlier testimony that I was pointing out, Mr. Coughlin, in his deposition and his affidavit, said no dogs, especially Rottweilers, especially Pit Bulls, especially Dobermans. Mr. Santiago confirmed that, and he said he agreed when I first moved in there. He told me no pets. He says it in his affidavit, paragraphs 7 and 12. Then Ms. Rodriguez said the same thing. The question was, you knew when Freddie told you, from what Freddie told you, that Coughlin didn't want dogs in the house. He says right. She confirms that in her affidavit, which are signed by Freddie and Carmen, Santiago, and Ms. Rodriguez. Getting to the next point that I was going to make to the court, the Olav case didn't involve, and the Bessent case didn't even involve, the deceit and scienter, which I think is involved in this case. Freddie, again I call him Freddie, I'm sorry, but Mr. Santiago and Ms. Rodriguez readily admitted that they kept the dog on certain random occasions at the house, and Freddie even admitted in his testimony that I lied to him and I did it real slick. To quote him exactly, the question was to Mr. Santiago, are you telling me that your neighbors there didn't know that you owned a dog? His answer, nobody knew because I used to do it very sneaky. I did it real slick without no problems. And I think the real issue here, and he testifies to this, is they needed a house. And if he got thrown out on the streets with his wife, or his girlfriend, his living girlfriend, and the children that they had there, I think there were 3 children listed on the lease that were living there, if they had been thrown out on the streets, Freddie and Carmen had nowhere to go. But yet they had this dog that they also testified that they didn't bring to the house until many months after they had first moved in, because they had knowledge and deceit in their mind when they did this. And I'm not trying to paint them into a bad picture, but if you're trying to come after the landlord for this type of problem, you have to look at how the dog ended up there and how he could have possibly known. And I think all of the cases that the appellant cited support that basis. And if you look, and I'll go through just a couple. For example, in 1987, the 4th DCA in the Vasquez versus Lopez case involved a situation where the tenant occupied the property for 7 years, owned a dog for 2 years, prominently displayed 6 bad dog signs on the property, and the sister of the landlord, who was an agent collecting rent twice a month in person, came to the house to pick up the rent checks. Completely different situation we have here with Mr. Coughlin, who testified he never picked up the rent, he never visited the property, had an agent, assuming arguably an agent, which was a plumber, that fixed a roof leak because some raccoons had chewed through a pipe. If he is considered an agent, he is definitely not operating within his scope of employment to then go back to Mr. Coughlin and say, hey, by the way, I saw a dog bolt. Because there's still no evidence in the record, because his deposition was never taken. There is no record evidence that the plumber even knew there was a dog on the property. So already, if we're going to the agent may have known, you don't even have any evidence that the agent actually did know. So again, we're assuming facts that weren't in the record.
The appellant argues that the agent knew because the agent asked for the dog to be kept away.
I agree that's a fact in the deposition testimony. I think that was in Ms. Rodriguez's testimony. But again, we don't have any direct evidence from a plumber that was there at the property that testified, or even an affidavit of the plumber. And I'm 99% sure that we produced the name of the plumber.
Was it clear which dog the plumber was upset about?
Again, you're right. There is no exact record evidence that the plumber knew that it was this dog, Macho, at issue. It could have been Beisha. And to set the record straight here for the court, Beisha came around after, as I understand it, this dog at issue was actually euthanized. The dog bit or scratched Geneva CRUZ, May 2904. The next day, the dog was put down. So between May 30th and September of 2004, Mr. Coughlin had no idea that this had even happened. And when they presented him with the lawsuit, when the process server served him with the lawsuit, he immediately came to see Freddie and Carmen and said, what is this? Why am I being served with a lawsuit? I had no idea you had a dog here. And then Freddie, of course, tried to say it wasn't our dog, it wasn't ours. They tried to deny it, but then they brought Beisha, the new dog, out from the back and said, here's the dog. He immediately stamped a 3-day notice on their door and said, get out of the house. No questions asked. So if there's any question of what he would have done had he known there was a dog there, I think that action is enough for this court to look back and say, well, there's evidence that he never had any notice, because if he did, this is exactly how he would have responded. But to give the court a further legal analysis of what's at issue here is if the court looks at this court in 1991, a summary judgment issue with a landlord that was held that could have been liable under a common law theory, the Giaccoli versus Bright case. In that situation, which I assert to this court is again completely different, because in that situation there was a neighbor that actually made a phone call to the management company responsible for maintaining the property's safety 2 days before, saying that a dog was chained to a tree lunging at children. And then what do you know, 2 days later the dog broke free and bit a child. That situation, I think, is completely different. There's actual notice to the agent, who I don't think there's any dispute the property management company would have been responsible for maintaining that property. It's what they were hired for. So in this district, if it's argued that that case is controlling, I think it's completely distinguishable for that reason alone. Then in 1998, the third DCA in a case called Rothschild versus Fritz, in that situation, the court ruled that there was a material issue of fact that remained as to whether the landlord knew or should have known of the vicious propensities of a dog, because in that situation it was again kept chained to a tree outside the property for 3 years that bit a plaintiff. In that situation, the landlord's father, who was also charged with the responsibility of collecting rent, frequently visited the property to collect this rent. And in the case that the court held that the father who visited the property and collected the rent, he actually visited the property where the dogs were kept. So again, we have another situation of where an agent who is charged with the duty of maintaining the property's safety in that situation had actual knowledge. If we look at the elements of an agent, I think this case is probably cited in every agent type situation made before this court. The Goldschmidt v. Holman case, it specifically sets out the agency elements. And in that case, the Florida Supreme Court, if I may here, held that there's three elements. One would be acknowledgement that the principal will act as an agent. for him. Number two, the agent's acceptance of the undertaking. And three, control by the principal over the actions of the agent. I think that this is completely taken out of context, because in this situation it was a physician operating, and whether he had control or whether the employer had control of the employee, I think was clear in this situation that he was an agent. But if you look at other case law on this same issue, and I'd like to point the court's attention to, I cited for the court Dickinson versus Graham Jones paper. That's another Florida Supreme Court case that held that the general rule is that knowledge acquired or possessed by an officer or agent of a corporation, again, assuming it's an agent or officer of the corporation, otherwise than in the course of his employment or in relation to a matter which is not within the scope of his authority, is not noticed to the corporation. And in that situation, I think an employee brought a fighting chicken to work, and he actually bit somebody while at work. And again, it's analogous, because I think if you're looking for the rule of authority when somebody is actually in a situation where they don't have the ability to report this type of action because they're doing something completely different, it's analogous in that sense. And in the same way that this employer had no idea this guy had brought his fighting chicken to the workplace, Coughlin had no idea that there was a dog on this property. So, I'm sorry, the plumber had no idea within his scope of authority that this dog was not allowed on the property. So, and to imagine a plumber to be my agent responsible for safety of my property is a scary thought, because a lot of times, a plumber or a carpenter is going to come in, he's going to do his work, and he's going to get out, and he's not going to call me and to expect him to say, hey, Mr. COUGHLIN, I saw a dog bowl on the floor, because at that time I think he was repairing the property in May of 2004. At that time, the testimony from Ms. Rodriguez and Mr. Santiago said the dog hadn't been brought there yet. So if there was a dog bowl there, it's a scary thought for me to expect my plumber to be telling me that there's things going wrong in my property when he doesn't even have knowledge of what the lease allows. Maybe the dog's allowed under my lease terms. So in that sense, I don't think it's safe to extend the liability of Mr. Coughlin as a landlord to his plumber as a legal agent of his to maintain the safety of his property. To address a couple other issues that were pointed out by the appellant, Ms. CRUZ's affidavit, which are record sites page 51 and 52, did not include any reference to any prior bites. So I just wanted to make that clear, that if there's reference in the affidavit, argument there's reference in the affidavit, that is, there was none. So there were no prior bites by this dog in the affidavit. If there was possibility that Mr. Coughlin could have seen the dog when he drove by, Mr. Santiago testified that the dog was kept in a shed in the backyard. So again, I point the court to this court's rule that there is no affirmative duty to inspect this property for a dog. With that said, for him to go into the gate, into his backyard, and open up the back shed would be completely out of his requirements within this court's ruling. And in that same sense, the opportunity to find this dog is not actual notice, which is required. Again, the court pointed out the correct rule with the affidavit issue, Ms. CRUZ's affidavit, Rule 1.510. It is hearsay, and it would not be. I hope, competent counsel, and I would have objected at trial to the entry of that type of hearsay information or evidence into this court. With that said, after this court reviews the consistent deposition testimony and affidavits of Mr. Coughlin, Ms. Rodriguez, and Mr. Santiago, which establish an undisputed record that Mr. Coughlin had no prior actual or even constructive knowledge of this dog on his property, following the controlling case law in this DCA and throughout the state of Florida, Mr. Coughlin asked this court to affirm Judge Whitehead's order granting summary final judgment and ultimately final judgment in Mr. Coughlin's favor.
Thank you, counsel.
Thank you.
Give you a couple minutes.
Your Honor, I believe that Mr. COUGHLIN and his plumber stand in different ground than Mr. Coughlin and his plumber. Mr. Coughlin is a businessman. He rents houses for a living. He employs people to work on those homes, plumbers and other drywall type people to work on those homes. I believe that his employees, or loosely implied, these independent contractors who do his work for him, would be defined as his own agents, since he employs them over and over again. This record is supposed to support Mr. Coughlin in his quest that there is no genuine issue of any material fact in this case, yet if you start with the first matter of record, the affidavits, they have been disavowed in large part by the people who signed them. First of all, that one person could not read or write English, and that Mr. Coughlin did not read the entire affidavit to him. And so I think if you're using building blocks, you have to make sure that those blocks have their own integrity. These blocks do not. Mr. Coughlin's attempt to put this case to bed, and that's what he told Mr. Santiago and Ms. Rodriguez, you just sign this and this case is over. You don't have to do anything else, this case is done. And I believe that the motivation for Mr. Santiago and Ms. Rodriguez to sign those affidavits is called into question because of this loan of money by Mr. Coughlin to Mr. Rodriguez, even in the face of testimony in this case that they were behind on their rent in large measure while they lived in his homes. It is the Gianculli case, Judge Lawson, that stands for the proposition. They say that they are not going to, as in Besant versus Matthews, that court declined to hold that any dog with pit bull ancestry should be deemed vicious under the law. However, it is not necessary that pit bulls be declared vicious per se under the law in order for the landlord and owners to be placed on notice that a tenant has a vicious dog. In this case, Mr. Coughlin's own testimony does that. Mr. Coughlin, in his laundry list...
Gianculli was the case where the pit bull was barking and lunging at children and then broke free, and that was the basis for the holding. They didn't...
Yes, sir. And the city...
There's not a presumption. The court doesn't state in that case that there's a presumption that if it's a pit bull, it's going to be dangerous.
No, sir. The court does not state that that is the presumption. The court merely recognizes the city of North Miami's ordinance that notes that pit bulls have a greater propensity to bite humans than other breeds, which presumably would have been the basis that Mr. Coughlin had for supposedly disallowing those types of animals at his rental properties. It's important to note, I believe, that Mr. Coughlin says, I did not want any of those kinds of animals on my property at all.
He didn't want dogs, period. He had a policy of no dogs. He didn't distinguish between Rottweilers, pit bulls, or Cocker Spaniels.
Actually, Judge, he said that he didn't want any dogs, and then he went on to state that these specific breeds, but that is nowhere in his lease provisions. This is a man who rents houses for a living. He has a policy in that lease about an indemnity agreement and being named an additional insured under an insurance policy gathered by the tenant. Presumably someone with that type of knowledge, that business person, if they truly, that is their deal, they would have that in their lease provisions.
Counsel, your time is expired.
Thank you, Judge.
Thank you both.